Доброго дня, колеги.
Good afternoon, dear colleagues. Today we would like here in the expert circles of parliamentarians and governmental representatives to discuss the topic which has been discussed for a long time as concerns investment environment and combating corruption and justice reform. This topic is relevant not only in Ukraine but all over the world. The topic of abandoning offshores, of doing transparent business. Half a year ago, when I worked with the Ministry of Economic Development, we started the discussion with businessmen, and we asked businessmen why most of agreements and investment they are structured and realized offshore. The first answer was protection of property rights and investor rights and justice system in Ukraine. It does not provide for implementation of the property right of ownership. Every investor, every businessman seeks most optimum in terms of tax legislation jurisdiction where his business would be registered to get dividends. The third answer, this lacking perfect corporate legislation today. This legislation regulating private companies is too far by its quality and opportunities from typical countries, model countries, where such as Cyprus, the Netherlands, and the system of UK law, which allows to build more complicated structures and provides for ownership rights in such complicated projects. So we will talk about reform of a legal system as a fundamental pillar to attracting investments to Ukraine, because we know how many investments flow to Cyprus. Cyprus is not the largest investment into Ukraine. As concerns tax reform, we know that the package has been submitted of reforming laws which would make tax code more flexible. We will pay attention to corporate governance in private sector. We live in independent Ukraine. We have been living in it for 25 years, but we lack the law to regulate most common form of limited liability companies. Most common form of companies. We have 500,000 limited liability companies. They are regulated by fragmented legislation pieces, and this prevent them from efficient protection of their rights. We remember that recently we heard many judicial cases due to the imperfect legislation on corporate rights protection. The new draft law, which is now in the committee, it has been developed, and the experts, wide circle of experts was engaged into developing, into drafting of this bill. The experts gathered and collected different ideas, analyzed them. They concern small and medium businesses, which should be at the fundament of our national economy. They are limited liability companies mostly. So this draft law, we expect its adoption in order for investments to be implemented, to be made into Ukraine, but not in other countries. So we will start with Andriy Volodymyrovich, Andriy Ivanychuk, who is the head of Parliamentary Committee on Economic Policy with the Verkhovna Rada. We give the floor to Andriy Ivanychuk. Please tell us several points. What is new in this law? Why do we need it? And we also then give the floor to other experts. First, I would like to thank everyone, to you and to those experts who were engaged into drafting of this bill. This is the complex reform of corporate governance which we needed for 15 years, talking about the offshorizing, and when we request business to be structured according to Ukrainian legislative framework, the company said that it is more favorable for them to have jurisdiction in other countries and to work in other countries because the corporate business processes, they like to implement them in the countries with UK law. That is why I initiated and I told that reform of limited liability companies, we needed it for many years, and that is why we drafted this bill 4666, number 4666, and our committee on economy now proposes it to the Verkhovna Rada to be adopted in the first reading. It consists of 7 chapters, and it has such clauses which were lacking in Ukrainian legislation. For example, the first one is the disposition of regulations between participants, between members of limited liability companies. This would provide for structuring. We introduce corporate agreements which are available in all countries which you name as investors into Ukrainian economy. Our shareholders will be able to sign shareholders agreement where they will be, according to the law, they can write down, they can set forth all the terms and conditions in such agreements for their further doing business. Also, there will be the clause to prevent raiders, seizures of businesses, and then also liabilities on paying dividends within specified period. This would protect minor shareholders because previously only major shareholders were protected enough. The European law, it provides for minority rights, for minor shareholders' rights protection. The same we included into our law. Management of limited liability companies can in this, according to this draft law, the management will be overseen by shareholders and founders in our legislation we lack regulation of withdrawal from members, but in this law we have relevant clause how to withdraw from membership. People, when they invest into some startup or business project at any stage, they will be able to withdraw and sell their shares. Also, large novel which we have already developed. This is oversight committee. Their status and role are well defined in the law. They clearly outlined the large block which previously was not unregulated for limited liability companies, often property requirements, property claims arise in the course of doing business. So we put relevant clauses into the new law. So by the second reading, I hope the bill would not be made empty of these very important clauses. This would be an impetus for the Ukrainian legislation to be consistent with the European standards. So I hope this law would be voted for in the Parliament. Thank you to the committee and you, Mr. Ivanychuk, because it is important when professional lawyers, professional companies, experts cooperate with the Parliament and MPs. They hear businesses because this way we can join theory and practice. I have a question to Natalia Sevostyanova. For LLCs are regulated by economic code now. And the discussion took place whether the economic code could be cancelled. And Mr. Petukhov, Minister of Justice, has said, let's cancel the economic code because it is obsolete. Today, when LLC law is in the process of adoption and shareholders law we have and state-owned companies law we have, would this be the step towards cancellation of the economic code? Is it consistent with today's, with present challenges? When we will have the LLC's laws adopted, along with the justice reform, would this help to prevent raiders' seizures? Do we need then have some big workshops to elucidate how it works in the world? Good afternoon, dear experts and our audience. The Ministry of Justice started very serious discussion whether it is efficient to have the economic code as it is, because some time ago it was created artificially to have separate jurisdiction for economic cases, and we analyze statistics how many cases are tried in economic courts and how many cases are tried in general jurisdiction courts. We think that this regulation may be cancelled and the legislative framework may be simplified, but this process may not be fast. So we have discussions among the lawyers circles and researchers. They say that we should maintain the economic code because our scientists, they have defended their thesis on this economic code. The law on LLC is very important. The most abundant companies available in Ukraine, and really their activities, they are regulated by fragmented pieces of legislation, and the court, they really use these norms of legislation in different ways. In our opinion, this is very progressive step, and once we have adopted the draft law number 4666, this would make regulations of LLC's activities far better. Of course, corporate agreements, they are also stipulated in this draft law. Whether we will have anti-raider effects, I think it would be. Because headed by Minister Petrenko, we try to deregulate, demonopolize the system and to prevent illegal seizures through decentralization, where notaries and local administrations they carry out functions, and we oversee an anti-raiding law has been recently adopted. It is about electronic signatures, and also this law stipulates withdrawal of licenses in case of some violations. So all teams which are working on reforms, we have adopted the amendments to the constitutions which took into effect in September. Now we are moving towards forming new legislative branch of power. We will have a new Supreme Court with very high salaries, higher than those of Prime Minister and the President. And we believe very much in this new branch of legislative power, which would be strictly monitored. It will provide very positive outcomes because this is very important. Only protecting small and medium-sized companies, we can ensure better welfare for Ukrainians.
Question to representatives of legal companies who directly work with clients. What do businesses expect? Do they expect this law? And what problems do you face in your practical work when you are working with your clients? What is lacking in regulation? And does this draft law reflect all those gaps? So tell us, please, about practical side of things. Thank you for inviting us here. We are really glad that we are here and discussing this draft law. And for us, Ukrainian lawyers, it is very important that MPs support us. Thank you very much for support to this initiative. This is your initiative that was supported by us, and we would like that this draft law become law, and we wish that modern Ukrainian law and legal system needs such a law, because we lack such laws in practice, and we, Ukrainian lawyers, we need to carry out our activities, but we know that there is different jurisdiction our colleagues work in, and as Yulia said, that the documents there are made according to other legislation. That's why our legislation should be done in such a way to reflect the interests of investors and interests of the companies who work in Ukraine, and we are ready to do everything for this. Answering your question, Yulia, I believe we try to take into account all those gaps that exist in today's legislation that needs to be reached, and we implemented the practices and created such a draft law that will help to work in Ukrainian environment. And as my colleague said, our draft law has positive aspects, and we lived before according to imperative norms, and we believe the practical lawyers believe that it shouldn't be like this, because entities that have such relations, they need to have the relationship as they want to have, and this should be a starting point for writing such a law. So this is how we see it. And why do they create such products in Ukraine? For example, such as holdings. Judiciary should be reformed, and this court reform should be implemented, and we also should provide the right to the parties to choose the life, how they will do it, and so this allowed us to write this draft law as we wanted it to be written. And my colleague said that, for example, corporate agreements are important, and this is included in the majority of legislation of different countries, and in this draft law we tried to embody those main aspects that we see in practice, the problems our clients face. Important issue was to regulate the issues of pledge and share, and in the majority of cases and or collateral, and modern business works with real assets, but according to current legislation they cannot provide this asset, and also to protect the rights of minority investors. And now there is practice that can be embodied in today's legislation. When the participant is excluded from the company, this should be done according to international standard. It is impossible to exclude this person, and it prevents investors from coming here. So there are a lot of other issues. So this draft law helps to protect the rights of investors, and we want that this draft law, due to the help of parliamentarians and especially you, Andriy Vladimirovich, was really adopted in the nearest future, because we, practical lawyers, we need this law. And during this panel, we hear a lot of good words, a lot of thanks, and I believe that this is one of the situations. A lot of specialists got involved in the development of this document, and I would like to thank Yulia and Andriy for this initiative, for the support. I'm thankful to the Ministry of Economy, the representatives of the ministry who formed the working group, and that we were involved in the work of this working group. I'm grateful to the committee who promote this draft law, and I attended the meeting of the committee, and they supported unanimously this draft law, and I hope that there will be the first reading and it will be positive, and it is really important. This draft law was really difficult to create this draft law. There were a lot of discussions. A lot of provisions of this draft law include compromise, and there are different opinions of consultants and those who work with majority, minority participants, and as we see it using our experience, and what we see that Ukraine as a jurisdiction is not competitive. And we believe that investors will come and will invest and create employment. And when we see, when it happens, they ask whether they can conclude corporate agreement or with a swap, or to introduce auctions. And we say no, and then investors leave for other jurisdictions. So Yulia said this correctly, that we see that the biggest investors of Ukraine are representatives of Ukraine, and our legal area should be developed. And before this discussion panel, I looked up statistics that was prepared based on survey made by a law association based on 10th forum, and different lawyers from Ukraine and abroad. They answered questions concerning corporate regulation, and they shared their experience and provided their recommendations. I saw that the answer coincide with our understanding. They share our opinion, and some things they were just impressing or said. So many people who answered these questions, about 70%, confirmed that they or their clients in the last 5 years have been investing into Ukraine, and they said they were satisfied the process, and part of them said that they were completely not satisfied or faced some problems. And as Anna said, there was a question about satisfaction, whether the respondents are satisfied with this so this and we asked, what do you want to have, and they said there should be corporate rights, corporate agreements, the status of a supervisory board. So there were many issues, really painful, of exclusion of participants, and this is a really painful issue. And there were a lot of problems in this area because this can block the activity of the enterprise or the exclusion of the participants. The investors doesn't like this. So we believe that I believe that by this draft law we will be able to bridge those gaps, and because the business, it is dynamic, we wanted to remove the obstacles for international business and to provide more opportunities to businesses in realization of their rights, and that also lawyers can fully realize their potential. And we hope that our market will prosper. And we believe that we all contribute to this. Thank you. I would like to say that a year ago, we had a meeting. You know, we say that IT is a driver of the economy, and we met with the Association of Venture Capital. The first question they asked, they said, we are not satisfied with corporate laws in Ukraine. We cannot do anything in Ukraine because venture capital is risk capital, and we do not have opportunities to exchange this debt into asset, and so we do not have options, and if that the participant is able to increase his share and to stimulate the efficiency of the company. So this was one of the most painful elements. So we can say that we should attract investment. And yesterday we had a good discussion with Sergey Guriev, who is chief economist of EBRD, and we were speaking about investment, and we should create a good environment, and corporate law does not provide for this now. And next is legislation on concession, and we were speaking about it for many years, but you know that this concession legislation does not allow the investors to come to Ukraine, and so we should adhere to the world practice in this area. And also LLC is the form for small and medium-sized business, and I would like to give the floor to my colleague who is working in the area of corporate law, and I would like to ask your opinion about this draft law. Is this law appropriate for small and medium-sized business? Because we were speaking about big business, but we have a lot of small and medium-sized enterprises, and they are in the form of LLC. And is this a good mechanism for small family business? Thank you, Yulia, for this question. So I would like to deliberate on this, and this is an interesting issue, and I greet everyone who are in this call. So it was difficult to make this draft law good for small and medium-sized business, because a lot of people want to be it only for big business, and people say that there should be different regulation for a big business and small and medium-sized business. But you know that we try to make steps in this area, because there are many people in Ukraine who are satisfied with the regulations that exist now, the block the new legislation, and the draft law 4666 is the balance that we were able to reach between regulation for small and big enterprises. And if it is adopted, it will provide opportunity for small investors and entrepreneurs that will choose this type of activity, even without a big knowledge of legislation, that they will be able to adhere to law properly, because all relations are regulated by this law. And for big enterprises who want to make a structure, who understand complex systems or types of carrying business, this law envisages a lot of positive norms that will allow the participants to form their relations as they wish to form. So there are also several areas in this draft law to find a balance between minority and majority. So in order to solve some issues, there should be unanimous voting, and we say that we should not get rid of the majority. Majoritarians can vote for something, and those who are in minority, they won't be able to do something. So if everyone agrees for this, so all this work that was carried out in the framework of the working groups and during previous years, they tried to find balance, and our role as experts in these working groups, we tried to see it as the state should see it, because the state has the obligation to regulate relations in order that there should be comfortable environment for business to develop. And the draft law on LLC, as any other law, regulates relations that exist. But when we adopt it, there will be something else, and it won't be regulated. So these gaps in all the countries, they are filled by courts, and in order to get rid of such an idea that our courts are bad, we should work with them. We should improve qualification of courts in concerning reforms. They should feel the ideology where this country goes, and judges lack this knowledge, not because they are not able to fathom this, but because we do not work with them properly. So there will be a proposal. We expect that this law will be adopted in the first reading, and it won't take much time in order to improve it. And of course, there will be some technical corrections, but we hope that it will be adopted on the whole, and there will be the proposal to the Ministry of Justice, and separately we will speak with the High Council of Justice, and in order and I support you in this too. carry out information campaign to explain where we move in this corporate governance. And what is the main is that we should regulate it, and it should be properly regulated, and our system differs from Anglo-Saxon law, because there they take decisions and take all the facts into account, and like it is done in common law, not unlike it is done in Ukraine. And this is only a start and the adoption of this law. So we should provide explanations to business, to the community, because everyone should learn in this new reality. And the law provides business with more responsibility. And if we are participants of such LC, we should understand that we have responsibilities, and we should adopt this draft law, and we should live according to the rules we established. So this is also responsibility of the business to implement these rights and responsibilities in practice. Because sometimes they write the agreement and then someone says, for example, that it is not in their interest, and they blame the state. That's why we should increase the level of responsibility among businesses, because we are speaking about business. And of course, business is always risky. And so if in Great Britain they won't implement as many agreements as here in Ukraine, so they would also have so many problems as we have. So if you have questions, we are ready to answer. So I believe you are right that the biggest investor in Ukraine is Ukraine. Could you explain why do you believe that small and medium-sized business will improve economic situation in Ukraine? And in Ukraine, we have big enterprises that are created by transnational corporations, and there are not many of them. But did you study their experience? Why? What obstacles do they have here? Not our pseudo-investors, but real European investors. Did anyone study this problem? What do they really lack concerning legislation? Thank you for your question. I believe that during this panel, we really understand the situation. As I said, representatives of legal lawyers from different sectors took part in the development of this draft law. And I worked a lot with big international companies, and our clients, they invest in Ukraine. They structure their business in Ukraine, and their business is part of the big transnational groups. That's why we took their experience into account. I won't name our clients. But you said that in Ukraine there are enterprises that work. We work with Ukrainian enterprises and with international companies that build plants or buy plants here, or create enterprises that work in extraction or in trade, in pharmaceuticals, and their experience is taken into account, and we know how their business work abroad, and we take into account their proposals. Thank you.
As concerns small and medium-sized businesses, I don't have statistic data with me on me today, but we have statistics in Ukraine. What is the contribution of big businesses and small and medium-sized businesses? 75% of taxes are paid by SMEs. Jobs are also provided by SMEs. The share of SMEs in the GDP is far higher than that of large businesses. This is the mix of Ukrainian economy. Having analyzed the economy, 90% are SMEs, and they provide 70% of product output. 1% is unproportionally high, the large enterprises, but returning to the logic of this law, talking about large businesses, we have yet another problem that we have many public companies which are not public. We work with the national regulator. We can't have such public companies with 99% shares in his hands, and many investors who enter Ukraine in the process of privatization, they say we have 1% of minor shareholders, and there are thousands of persons. So in order to have a general meeting, we should hold this meeting for thousands of persons and them notifications and so on. So reform of corporate law would mean that this public partnerships, they will become LLCs. So when investors come, when big companies come here to our market, they come in certain legal forms. We would not like to have quasi-investments any longer. We do not want to continue this process, these practices. Why we had quasi-investment practices? We should convert debts into shareholders' capital. This means non-financial liabilities will be recognized. So we believe that this draft law will change fundamentally the approach and understanding of investments, because many our leaders, they do not understand the difference between loans and investments. The opportunity to convert the loan, this is the investment. A very small remark to what you have said. We should also take account that those limitations put by the National Bank of Ukraine on withdrawing investment from Ukraine, they fear of foreign investments. They stimulate, they promote investors to give loans, but not investment. Because now you can't fund your enterprise in Ukraine, not being afraid, then you will not be capable to get your investment back only by giving loans. Thank you very much to our colleagues and those experts who took part in drafting this bill, and thank you to Andriy Ivanychuk for heading the parliamentary committee who drafted the bill, and we call on MPs to adopt it in Verkhovna Rada. This would improve business climate. Improvement of business environment means specific steps on the part of our Verkhovna Rada, of our parliament and our government. Besides fast victories, we should put systemic sins such as this draft law, which would regulate more than 500,000 economic entities in Ukraine. Thank you very much, and we hope the law will be adopted soon. Thank you.